Ladies and gentlemen, Floyd Abrams.
Thank you. Thank you all for coming. It's a special privilege, really, to be here at Google. I want you to know that I hear about Google all the time in the course of the work that I do, mostly because when I teach students at law school and when I talk with professors of First Amendment law, one of the first things they always say is, well, look, First Amendment's about the government. And we have things pretty well under control there. The single most important decision maker in the world about freedom of speech is Google. And Google's rules and what Google decides goes on or off is center stage very often in discussions at law schools and in a variety of places you wouldn't think so. The First Amendment, of course, as part of the Bill of Rights, applies only to the government. It's a limitation on the government. It prevents the government from interfering in a variety of ways: freedom of speech, freedom of the press, freedom of religion, freedom of assembly, etc. And I've done a lot of teaching about it, and my recent book tries to deal with a lot of the events and a lot of the conflicts that have arisen with respect to the First Amendment, really in the last 40, even 50 years. Some of them recur. And Google's always around the corner, by the way, when they do recur. One chapter of my book deals with confidential sources of journalists. I've been involved in a lot of battles with the government and private parties who have sought to get court orders requiring journalists to reveal the identity of their sources. Journalists promise, as you know, confidentiality, try to keep those promises when they make them, and they wind up in court sometimes. And sometimes they don't. And that's been one of the big issues of the last few weeks. As you've read with respect to the Associated Press case, the Department of Justice, in the course of a leak investigation in which the department was trying to find out who in the government provided certain information about a terrorist attempt in Yemen to bring down an American airplane. The Associated Press had received information about that, and they behaved in a particularly responsible way. They went to the government, they went to the CIA, they asked, would it do any real harm if we published this? And the answer was yes. We're in the middle of doing what we're doing. Someone could be hurt, and so they didn't publish anything until they learned that the government was about to hold a press conference the next day announcing a great success in preventing the terrorists from bringing down this American plane. AP went to press then, did its story, and in the meantime, a leak investigation had begun. Who told AP about this? And the basic rules of the game that the Department of Justice is supposed to play by are rules in which the press goes last. They're supposed to take lie detector tests. They're supposed to interview people. They're supposed to do all the things to try to avoid conflict with the press until it's absolutely necessary to go to the journalists themselves and either try to get a court order to require them to reveal their sources or somehow work something out which would help them to learn their sources. The only exception to the obligation of the Department of Justice in this area, the only time when they are allowed not to talk to the journalist, not to talk to the AP in this situation, is if doing so would interfere with the, quote, integrity, unquote, of the investigation itself. You know, would blow the investigation, would make it impossible for them to find out for one reason or another who leaked the information. They did not tell the AP that they were interested in their telephone records. They went to the telephone company and served a subpoena on the telephone company saying, turn over to us the AP records of 20 or so telephones used by over 100 journalists over a 2-month period. And the telephone companies turned it over. And that's been the basis of a great deal of controversy in the last week, really, because this is all very new stuff that we're talking about. People, myself included, have been critical of the Department of Justice, basically saying we can't imagine a scenario in which telling the AP that you wanted their phone records would have interfered with the integrity of your investigation, except for one scenario, and that is that if you told them, they would go to court, which is true. They didn't go to court because they didn't know that anyone was interested in their phone records. And it's true that if they went to court, months would pass. Now, that's not a very good reason, certainly if you think the First Amendment is involved, if you think that journalists have or ought to have a right, as a generality at least, not to reveal their confidential sources. And so the controversy about that one is basically, did the Department of Justice play by the rules in going right to the phone company instead of going right to the Associated Press in this area? The other one, which is more relevant maybe to Google, is the subpoena that was served, a search warrant that was served, and again, we learned this only 3 days ago, on the chief Fox correspondent in Washington in the course of another leak investigation. That one about information about North Korea and their atomic capabilities and facilities and the like. And in that one, the government did, and we're not sure of all the things they've done, but a lot of things to try to find out who the source of that information was. And not having learned it or not having learned it with sufficient clarity, they took the next step. They went to a court. There is a court, a secret court, as it happens, which deals with certain types of highly sensitive national security-related matters. And they asked for the right to serve a subpoena, really a search warrant, on Google. They said, this journalist who got this information about North Korea himself is a potential criminal because he spoke to someone in the executive branch of government. He cajoled him, he flattered him, he appealed to his vanity. All these words are from the application for a search warrant. And he ultimately persuaded him to provide information that he wasn't allowed to provide. Now, most journalists would say what the journalist did is almost a definition of journalism, cajoling and flattering and appealing to egos of a potential source. But in their application for a search warrant, the government said that's a crime under the Espionage Act of releasing information, even a non-government employee, releasing certain type of very sensitive information which he had no right to release. That's a position the government had never taken before. I mean, that's big news, to accuse a journalist of violating the Espionage Act for basically acting like a journalist. And it rightly, in my view, has been the subject of a great deal of attention and a great deal of criticism of the Department of Justice. The alternative offered by the FBI agent who wrote or signed on to this affidavit was, well, if you didn't violate the Espionage Act, At the least, you are an aider and abetter, somebody who worked with the guy in the executive branch who provided information he wasn't allowed to provide. And that, too, is something which the government has never maintained. I mean, historically, we've had a situation where the press and the government have often been in conflict, have too often been in bed together, but have worked out a sort of general modus vivendi, have worked out a general, you do your thing, we do our thing. A former Secretary of State writing to a New York Times columnist put it this way. He said, your job is to pry, mine is to keep secret. And both sides have generally understood that to that extent at least, there's an inherent conflict in what the government wants by way of secrecy and what the press wants in the sense of getting information that they can release to the public. And generally, you know, they've gotten along pretty well. Some people think too well, at least in the sense that there's no doubt that Washington is and has been for years, you know, a hotbed of leaks. The Department of Defense leaks information when the Secretary of Defense advocates cutting back the budget. I mean, where does the New York Times, where does the Washington Post, where do the television stations get information that people are really worried about cutting out this weapons system? It's usually from leaks from within the Pentagon. And we read lots of leaks all the time from security agencies, from the CIA, from all over, certainly from the White House. And that's true in all administrations. So what happened here is that Google became involved as the entity which received the papers from the court saying, turn over the personal emails of the journalist. And it did so. And that combination of events, the Associated Press issue and the Fox News journalist issue, have been one of the sort of three tough events in terms of the presidency, at least, that we've seen in the last week or two. You know, the others being the Internal Revenue Service matter, and depending on your view of the matter, that which has been coming out about the events in Benghazi, et cetera. And for those of us in this area, the government walked over a line that had been pretty clear in the past in accusing in so many words the Fox journalist of having committed a criminal act by asking questions of someone who, and I'm trying to be fair now, who wasn't allowed to answer them. But that's the way things have generally been. In my book, I try to deal with a lot of different subjects which in one way or another affect freedom of speech and freedom of the press. And in a class I taught at Yale Law School last year, we devoted a few days to the subject of privacy, personal privacy, and of defamation, libel, slander, saying something about someone else which is untrue and for one reason or another unprotected by the law. We asked a Yale Law student to come as a visitor, a speaker, a guest to the class we taught on this subject. And the reason was that she had been victimized by a website which was anonymously run, but this all later came out, by a law student at a different law school who had created a website basically by reading another website in which students in college were talking about what law school to go to. They all had anonymous names, but he basically tracked them. And he tracked attractive women. There were Facebook-like pictures in the law schools after you enter. So he would compare what people were saying while they were seniors in college about, I have a choice between this law school and that law school, and I've done this and that, and this is my history, etc., with the pictures that he saw in the books of the great law schools. And he would be able to find some women, he didn't know any of them, to find some women who he could be sure were the same people that were talking in college, who went to this and that law school. And he'd put their picture in, and he would make up stories about them. Terrible stories, mostly sexual, but not limited to that. But just saying awful things about them. And saying them, of course, with anonymity, life being as it is in this age. A few of the women were law students at Yale. They got pro bono assistance from some lawyers. They went to court. They got a court order requiring disclosure of the anonymous speaker, which one can get in certain circumstances, but is not the rule. And we had her in class to talk about her experience. And I think all of us were really surprised on a few levels. One, there were three of us who were teaching. We're each about 10 years apart in age. And then you take another 20 years off between the youngest person and the student. And all of us that were teaching were sort of struck by the fact that we seemed angrier than anyone in the class. The students said, oh, we know that website. No one believes anything on that website anyway. And she said, the victim, the person we were especially not just sorry for, but felt had been terribly abused, said, well, look, maybe I shouldn't have sued. Maybe it wasn't a good idea. That just got, more publicity. But it's all about page 1 of my Google. Said that, someone looks me up for a date. Someone looks me up for a job. And there are these charges on page 1. If it only weren't page 1, she said. And so she said, I needed an answer. I needed a court to say, in effect, it's all untrue. And she's gotten that. But it's an example, I think, of how, with new technology and the like, we have new legal problems and new First Amendment-like problems. Is anonymity protected on the websites? Can a court, which is part of the government, can a court issue an order? Should a court issue an order? When should a court issue an order requiring the anonymity to be breached? I go back a long way in this area, and one of the first cases I worked on, which is discussed in this book, was all the way back in 1971, and it was the Pentagon Papers case in which the U.S. government went to court to try to get an order stopping the New York Times from publishing information it had received about a secret study that the Defense Department had prepared about how we got into the war in Vietnam. The Secretary of Defense, Robert McNamara, had asked for a study to be done answering the question, why were we in the war? There were people that thought maybe he should have read that before we got into the war, but in any event, he asked that it be prepared. The Defense Department brought in a bunch of scholars and other people to write it. It was sort of a devastating document. It was over 20 volumes. Devastating because it really did show that starting way back in the mid-40s after the end of World War II and thereafter, that American presence in Vietnam grew and grew, and that the public was not accurately told what our involvement was, why we were there, what we were doing, et cetera, et cetera. In any event, one of the authors decided that the war was wrong. He thought it was a war crime. And he made available to the New York Times almost all the volumes that had been prepared of what became known as the Pentagon Papers. And the Times started writing articles about it, and the government under President Nixon went to court seeking a court order requiring the Times to stop publishing this material, which was labeled top secret, which is the highest level of secrecy in the government, even though not everything called top secret really is, but that's another story. But in any event, that's the highest level in theory of classification. And we won the case, and it was a great victory. It would have been an even greater defeat. The country really would be different if we lost the case. But in any event, we won the case. And there was a moment at the end of the case that I've often looked back on, particularly with respect to WikiLeaks and their behavior, of course, much more recently. When the case was over in the lower court, in the federal district court, the federal judge ruled in our favor. And he called me into his office, his chambers, and he called a senior partner of mine into his chambers. And he said something like this. He said, you know, you've won the case, at least with me. The Times can publish what it wants. Now I want to talk to you as a private citizen. I'm not a judge anymore because I'm finished with the case. There is some material in there, in particular, a contingency plan for what was called SEATO, the Southeast Asia Treaty Organization, the U.S. and various Asian countries in alliance together, which I really think the Times shouldn't print. And it's this and this and this. And I really wish, and I use the word wish, I really wish you'd tell them that that's what I think. I'm not entering an order. Again, I'm not a judge anymore. I'm just telling you what I think. And we said we would tell them. And we did. They had already decided not to publish a lot of material from that contingency plan. They took another look. They decided not to publish some more of it and to publish some of what the judge had identified because the Times didn't think that it threatened national security. And I've always thought that's the way the system's supposed to work. Basically, the judge giving a very, very wide berth to the press, except in the most extraordinary circumstance where publication, is very likely to really harm national security in a very real way and imminently, and as a result of publication, not as a result of anything else. And I thought, he'd behaved, and I still think, he'd behaved really well in ruling in our favor at the same time he had these concerns. And I thought the Times behaved well in taking seriously what he said about how he thought that this particular material might do some harm to national security. I contrast that with the WikiLeaks situation, where WikiLeaks, in my view, has been reckless in its decision-making about what documents to release and what documents not to release. One example, WikiLeaks received apparently from this Private Manning, who's now on trial, approximately 91,000 military reports from American servicemen in Afghanistan. WikiLeaks at that time had already been under considerable criticism for the release of other information of a variety of sorts, and withheld at least immediately some thousands of them, at least while they read through them more. But they released to the public 77,000 of the 91,000. And a journalist asked Mr. Assange at a press conference, the head of WikiLeaks, have you guys read the 77,000 reports that you're releasing? And he said, well, we've read about 2,000 of them. The journalist said, how can you release them? And the answer was, we don't have any reason to think that they would harm national security. Now, my reaction to that is, first of all, this is not the stuff of journalism we're talking about. Journalists don't hand out documents. They read them and report on them. But that's not enough of an answer, because the First Amendment doesn't protect just journalists. If Julian Assange is what I think of him as being, a sort of political activist, that doesn't mean he's not entitled to First Amendment protection. He's just not the press, if I'm right, but whether he's the press or not, if he ever were charged, if he came to the U.S. and were charged, he would have some serious First Amendment defenses, at least if the documents did not do significant harm or did not significantly threaten national security in one way or another. That said, there's a difference between what I would call press responsibility and what the First Amendment protects. The First Amendment doesn't require responsibility. It doesn't require judges to pass on what is responsible journalism or not. And it doesn't require judges to agree or not agree with publication or release of document-like decisions. What it does do is to say the government's got to keep its hands off except in really extraordinary circumstances. And that's especially true when you're talking about people who aren't in the government. People who are in the government have special obligations, and the Supreme Court has indeed gone so far as to say that even if there were no contract, as there is, between the CIA, say, and employees, agents of the CIA, and they make them all sign a contract promising not to disclose things that they have learned, et cetera. But even if that were not so, the Supreme Court has said we would treat it as if there were a contract, because the relationship, at least of the CIA, to the government and the role of the CIA is such that it's that important to have that level of secrecy. So in all these areas, we see the First Amendment is a barrier, a great barrier, hardly ever a complete barrier. I mean, the courts have always left, and Congress has always left, some sort of out in situations of great national peril, or in other areas of law, libel law, privacy law, and the like, while those bodies of law lean over very strongly in the direction of the press or of speakers, of revealers, of talkers, and the like. While all that is true, we still have libel law in America. People still sue, not so often, not as often as in other democratic countries. I mean, we provide so much protection for free speech that a lot of the lawsuits which are commonplace in other democratic countries simply don't happen here. I mean, in England, the Prime Minister brings libel suits. The Queen brings libel suits when people say bad things that they make up. I know you'll be shocked to hear that the press occasionally makes up stuff. Not the people I represent, but others. But what's interesting to me about that is that it leads to sort of a different culture. The fact that it's so hard to win a libel suit for a public official in America puts us in a situation where when a candidate for office, say, is accused of some sort of misconduct, the press doesn't go around and say, "Are you suing for libel?" Or, "How can you let that be said? Why don't you sue?" In England, the candidate would be expected to sue. In England, it would be assumed if he didn't sue, it must be true. And that was just an unintended consequence of the difference in libel law that we have in the two countries. One of the greatest First Amendment contributions that our Supreme Court has given us is really to move us away from English law, notwithstanding that our law comes, initially certainly, from English law. I mean, they are the mother country in terms of American law in most areas and in most constitutional areas. But time and again, but starting some years back, the Supreme Court has said the purpose of the Bill of Rights, the purpose of the First Amendment, was to give Americans far more protection against the government than exists anywhere else in the world, including England. And so you have situations where, let's say, a trial is going on, a highly publicized trial, Jodi Arias, anything you can see on television or read about on a regular basis. In England, the press is allowed to report fairly and accurately about what happens in court. They're not allowed to report on a confession until it's introduced in court. They're not allowed to report about a prior criminal record of a defendant unless and until it is introduced in court. Here, what the press learns, the press can publish. Here, if the press learns that some defendant in some case has confessed, it's published. Well, how do we deal with it? How do we assure a defendant a fair trial? We do a lot of more things than they do over there, in part because we have to, but in part for other historical reasons. We do a lot more things to assure a defendant a fair trial. That's one of the reasons our trials take so long. That's one of the reasons you sometimes see people going free who may have done terrible things, but because the government has failed to meet some technical sounding, but nonetheless significant element of proof. And all that really began as far back as 1941, in which the Supreme Court had a case in which there had been a strike, and this was right on the verge of World War II, the American World War II beginning. It was a big strike of the Teamsters, the people who work loading and unloading on boats and ships and the like, in California. There was a court order for them to go back to work. The union defied the order. The head of the union was held in contempt of court, and he was up for sentencing in front of a judge. And the Los Angeles Times had an editorial saying, "Send him to the jute mill." I'm not even sure what jute means, but it's not a good place to be sent. He said, the LA Times said in the clearest terms, you ought to be as severe as you possibly can. This guy is interfering with national defense, and you really ought to crack down on him. In England, then and now, that's a contempt of court. The editor would go to jail in England today for saying that, on the ground that it interferes with the processes of justice. When I was in college, I agreed with that. I wrote a whole thesis arguing that we ought to move towards the English system because I thought it made a sort of sense. I've since come to different views after I started practicing law, And after I started meeting some journalists, and after I started realizing some of the benefits, and hopefully understanding at least the potential harm, but some of the benefits of living in a freer system. Basically, what our Supreme Court said in that case, in a decision by purest chance, decided the day after Pearl Harbor. The court said something like what I almost quoted to you a few minutes ago. Nothing is clearer about the drafting of the American Bill of Rights in the U.S. Constitution, the first 10 amendments, than it was designed to provide American citizens with far more protection in all these areas than exist elsewhere in the world, and particularly in England. And unless publication, it will be such a clear and present danger to the administration of justice, unless a judge simply can't function for one reason or another. Press is free to say what they want, free to criticize the judge, free to lobby the judge, free to write editorials, basically saying you better send this guy away as long as possible. Judges, Justice Hugo Black wrote, are supposed to be hardy in nature. They're supposed to be strong. And we will not allow, he wrote, free speech to be interfered with because of the possibility that a judge will be weak-kneed, timid, unwilling to follow the law because he or she is being criticized. Let me offer you a final example of one of the very controversial subjects talked about in my book, and it's a subject where my views are not very popular with most of my friends, most of the people with whom I tend to agree politically and the like. That's the case you've heard about called the Citizens United case. It was a decision of the Supreme Court 4 or 5 years ago now, which said that it was unconstitutional, that it violated the First Amendment for Congress to pass a law saying that if any corporate money was spent for or against the election of a candidate within 60 days of an election, and the money was spent to endorse or to denounce the candidate, that was a crime. The purpose of the law was to try to deal with the problem of money in politics, too much money, too few people, too much power for those people, and the like. Serious stuff. But raised very significant First Amendment issues. A conservative group called Citizens United, which was partially funded by corporate grants, mostly not actually, but partly, did a movie, a documentary, they said, about then Senator Hillary Clinton. This was 2008. Then Senator Clinton was the leading candidate for the Democratic nomination. Of course, Senator Obama was nominated. But at that time, it looked as if Hillary Clinton would be nominated. It was an hour-and-a-half program, film, and it was all attack from beginning to end. It was a screed, a primal scream not to elect her as president. And it was the desire of this group to have it on pay-per-view. Because it was within 60 days or 30 days of a primary, which was another key point in the statute. Within 30 days of a primary, 30 days of a political convention, or 60 days of the election, that would not be allowed on television, on cable, or on satellite under the statute. And the question was that constitutional? The Supreme Court divided 5-4. The 5, it's the court's most conservative members, wrote an opinion. I was one of the 2 lawyers in that case who were on the side of Citizens United, wrote an opinion saying this statute violates the First Amendment. We're talking about speech about an election. We're talking about who to vote for president. There is nothing more important that we have free speech about, and it doesn't matter that the money comes from a corporation. The court said we've had case after case involving corporations, mostly ones that own newspapers, broadcasters, and the like, but not just those, who've engaged in speech. We've said it was protected, and that can't be overcome here. It remains an extremely unpopular opinion. President Obama denounced it in his State of the Union message the January after it came out, and has said more recently that he's considering supporting a constitutional amendment to reverse it. The New York Times, Washington Post, most of the leading newspapers, in fact, I would say really almost all of them other than ones that are decidedly conservative, like the Wall Street Journal, say, or National Review as a magazine. But the great balance of press commentary has been extremely hostile to the opinion, basically on the ground, is a perfectly understandable one, that it allows corporations perhaps to have too much power, spend too much money, have too much influence on what happens in the country. My view is that that is a danger. I don't think we ought to deal with that danger by limiting speech. If we want to pass laws designed to have a more egalitarian, a more equal society, I think we can do it. Congress is of no mind to do it now, but I'm just saying, if they wanted to do it, if they wanted to raise taxes on corporations, if they wanted to have stronger antitrust laws, if they wanted to do economic things to deal with an economic problem, my view is that's one thing. You can like them or not like them as ideas, but they have nothing to do with the First Amendment. Congress is free to do those things. The states are free to do those things. We don't even have to have corporations. There's nothing in the Constitution requiring the existence of corporations. States allow corporations to exist. But my view is that when you're talking about speech, about elections in particular, when you're talking about political speech, when you're talking about who to vote for, that's the area in which Congress ought to have the least power, not the most, and that Congress ought to be obliged to stay away from areas such as this and from passing statutes such as this. That's a very controversial position, but I did want to set it forth. I wind up the book like this. I say, is it too much to ask that people who say they care about the First Amendment, everybody that is, really mean it when they say that everybody ought to have a free say about what they think? Do we really mean it when in one of the great old Supreme Court opinions it says the First Amendment means we protect the speech that we hate? And the question that I ask throughout this book is, do we really mean that? Or are we really in almost the same situation with the First Amendment as we are with everything else in our society? You know, left wants left speech, right wants right speech. Everybody is willing to cut into the speech of the others. And I sort of appeal to the reader to support First Amendment freedoms across the board, to support the ability of people basically not just to have freedom of thought, but freedom of expression in the ways that the First Amendment most obviously protects. Freedom of speech, freedom of the press, broadly interpreted, and only limited in very, very rare circumstance. So that's what the book is about. I'm glad to appear before you today. I'll be glad to take any questions or comments. I should say first, you have to agree with me, though, right?
So I actually wanted to ask you sort of a follow-up question about the Yale law student.
Yeah.
It's really less a First Amendment question than a sort of just your views about the privacy issue involved, because I think sometimes these issues get a little muddled in people's minds. So if we sort of walk the cat back a little bit there, and we just take the situation where the students in college and makes statements, on some website, right? Although with an anonymous name about, I'd rather go to Yale than Harvard because I think Harvard Law School stinks and Yale's much better, right? And then ultimately she winds up getting into Harvard instead of Yale, and whether it's the person on that website or somebody else tracks down this public, although anonymous statement, and also through non-criminal means determines that this person is now a student at Harvard and puts the two of those together and publishes that information. I don't think there's a privacy expectation there, right? Because they put all that information out there, but I'm just curious as to whether you agree or not.
No, I agree, but there is a libel one if they make up stuff about her.
Yeah, right.
Which is what they did. No, but on a privacy basis, I agree with you. Look, one of the realities these days, these years, and well into the future, so far as we can see, is that people are saying so much about themselves online and otherwise that willingly or not, or thoughtfully or not, they're giving up. They're choosing to give up, in a sense, their privacy. If you write something down and send it out and don't find some effective way of concealing who you are, it's your problem.
And if I could just ask one follow-up question on a different subject about the question of leaks by the government.
Yeah.
My sense is that you agree that it can't be stopped at this point. It's essentially become a policy tool for whichever administration is in power in order to push the political debate one way or the other, or influence Congress or influence the public. But I wonder, I'll speak for myself, I feel like there's a really corrosive effect there. And the best example I can think of is the lead up to the Iraq War, where it turned out that the administration was feeding the New York Times information and then quoting the information that it had been fed on the Sunday talk shows in order to say, well, look, it was published in the New York Times, this was true. And so it seems like it's one thing to say, okay, we're going to, any government, doesn't matter whether it's Democratic or Republican, it's one thing to say we're going to leak because we want to push public policy one way or another. But it's something else then to implicate the newspapers directly as a sort of a policy-making tool. And I just wonder what you think about that.
I agree. And as you said, by way of introduction, this is not a legal comment, and your question wasn't about the law. The Iraqi situation is an interesting one in some ways. I believe that the scientists who were quoted in those New York Times articles believed what they were saying. I also think I know that the reporter who I represented, who wrote those articles, believed what she was saying. But the government, certainly we know now, was engaged in a campaign to gather public support for the war that included in the information they provided were false statements, not just proved to be false, but known to be false, and that is unacceptable behavior. And your example, it couldn't be more on point. They not only leaked the information, then when it was published, they said the New York Times said, as if they had nothing to do with the information getting to the Times. I mean, that sort of cynicism sounds like the stuff of novels. But that's what happened. And what can you say other than it's worthy of condemnation? We hope it doesn't happen, or we hope if it does happen, it's exposed. Anyone else? Yes. Did I see a hand, or did I see? Yeah.
Hello.
Hello.
So, from what I know, the First Amendment protects citizens against what citizens say from interference by the government. But I was wondering, it still allows interference by private individuals and corporations. So what do you think? Should something change there? Should this be allowed, or should it become more strong in favor of protecting? Because it's not only the government that can threaten your speech. Increasingly, where you write your comments, where you create speech is owned not by the government. Is like a platform that is online, or like where you're employed, the employer has some power over what you can say, and you can't control that. Should the government have, per se, a positive obligation to ensure that citizens have freedom of expression up to a point, and ensuring that other entities do not interfere with this right?
That's a very, very serious and powerful question. First, simply as a legal matter, the answer is easier than the policy question that you're asking. As a legal matter, the Bill of Rights applies only to the government. It's even phrased, Congress shall make no law abridging the freedom of speech or of the press. Congress has been expanded to mean the president and the states and the courts, etc. But it's all government entities. But your question's a lot better and more interesting than that. There are countries that do protect, far more than we do, private speech against private institutions, corporations, employers. We are basically a laissez-faire country in general in that respect. People can say what they want, and other people can hold them accountable, which is to say they can get fired for saying it. They can be punished, so long as it's not the government doing it, for saying it. And the question of whether, putting aside the Constitution now, whether we think it's a good idea to, in effect, import the government into that situation by saying to the government, why don't you do something to assure that private speech shall not be so subject to control or sanctions or the like by large, powerful private institutions. My reaction is that I don't think we should go in that direction, in part because I don't trust the government to be, in effect, the decision maker, or even to interfere for the good purpose of protecting more speech. But it is a very real issue, and for a lot of people in a lot of situations, it's much more real than any of the fights that I've been talking about between the government and the people, or the government and the press, and the like. One of my concerns is that there has been a tendency abroad. One of the things I think we've learned as a country is that there really is a domino effect, to use a bad phrase from a different generation, when you sort of put the government into the role of helper, assurer of free speech rights, is that there's a great tendency, and there has been a great tendency and abroad, to wind up with the government in the newsroom. and the government as decision maker, not just about keeping people from keeping other people from speaking, but in other situations. But that's just a very short answer to a very hard question. This is not a promise, and there's no reason for you to care about what I'm about to say, but I do owe the Yale University Press one more book, and that is something that I've thought of writing about. Yes? Oh, sorry.
As technology continues to develop, we're finding more and more ways to communicate. We had landline phones and wiretap regulations, cell phones, cordless phones, and now electronic communications, texting, online, email. And these are all mechanisms of person-to-person communication. Do you think that technology is fundamentally changing the way that we view and are given these rights? And do you think that's the right thing to happen?
I don't have any doubt that technology is changing the way we exercise the rights and therefore changing our ability to engage in those rights. Also, as technology changes, the issues will change, although have the same base sort of characteristics and arguments about them, about what the role of government is in assuring fairness, as per the last question. Net neutrality comes up. I mean, other ideas are voiced and placed on the public agenda to try to deal with the reality of new technology. I mean, one way it comes up is simply one where the issue then becomes, is there any more need for this regulation or that regulation at all, since there's so much speech in this area? I did a case for Time Warner Cable, which is awaiting a decision now, about whether it is still constitutional under the First Amendment for Congress to have required cable companies to carry networks, basically, that they don't want to carry. And one of the arguments we made is, look, there's so much speech from so many sources now, you got to let them go. And if not now, later. So the changing forms of technology affects everything. It affects privacy, we were talking about earlier. It is even leading to some very interesting cases in the libel area, for example. One judge wrote an opinion basically saying online speech by its nature is not taken as literally as the speech in my book, with a hard cover on it and everything. People don't mean it. It's more casual. It's not taken to mean the ultimate meanings of what one might view it if it appeared in a different medium of communication. And I don't have any doubt that we're going to need a lot more decisions and a lot more legal decisions as the on-the-ground reality changes. And of course, the law is always behind. Technology is way ahead of anything the law can handle or predict or be ready to deal with. And by the time cases come up to the courts, sometimes the technology has already changed to such an extent that the issue isn't even that relevant anymore. But the thrust of your question, I agree with, and we're going to. The pace of the change of technology in this country is so great that it is very hard for the law to keep pace with it in terms of even trying to deal with it. And so and in a society where, as I suggested earlier, Congress can't agree on almost anything anyway, it means we'll be sort of even more laissez-faire, as it were, for better or worse, There'll be probably less regulation, for better or worse, because no one's going to be able to agree in any event on what to do about it. Yes?
Does the Constitution contain protections for journalists who need to misrepresent themselves while uncovering facts that they intend to publish, say in a way that contravenes a contract that they might sign or something like that?
Well, not to breach a contract that they signed, no. But generally, a journalist who suggests to someone that the article is going to be good for him is not held to that in the courts. But there are situations in which journalists promise something, and then the question is, what should the law do about it? One really interesting case occurred in Minnesota 15, maybe 20 years ago. Two candidates running for lieutenant governor of Minnesota, and one of them says to a journalist, I know material about my opponent, which I'm ready to tell you if you promise me confidentiality. Really bad stuff. The journalist, a young journalist, promised confidentiality. And he told the story of how his opponent had been arrested as a teenager for shoplifting in a Woolworths store. Not much of a crime. She goes back to her office and she tells her boss, editor, what she's found. The editor says, that's no story. The story is he's leaking this crap. So that's what we're going to publish. And she said, but I promised confidentiality to him. And he said, no, the story here is, that's the sort of stuff he's saying. So they published that. The guy lost the election, and he sued. And he said, I had a deal, a contract-like situation with the reporter. And so the question, the issue came up to the Supreme Court, and the court said that it would be constitutional. It would not violate the First Amendment for Minnesota to allow a recovery in that case by the candidate. The press side had argued, we were telling the truth. How can we be in trouble by telling the truth? In libel law, you always win if you tell the truth. How can? And the answer was, well, you made an agreement, or at least that's what a jury found, that you promised confidentiality and you have to keep the promise. Yes?
That's all we have time for. Thank
Right.
you very much.
Thank you all very much.